Thank you, Kanika. I follow some very esteemed speakers, so I will not take much time. I know I'm standing, it's a Friday evening, I'm standing between you and your drinks and your dinner, so I'll keep it very short. Um, I am talking about transforming arbitration using technology and digitization. We've talked about India is poised. We can make India the hub for technology. And we have made a lot of inroads into adopting technology and especially in arbitration. But we still, I feel we have a long way to go. Now, what is technology? And when we talk about technology in arbitration, what exactly are we talking about? So ICC have established some guidelines, which is leveraging technology for fair, effective, efficient international arbitration proceedings. And in that, they sort of talk about what they mean by technology in those guidelines. So they have covered things like online e-filing platforms, storage of information, sophisticated cloud-based case management platforms, software and media used to facilitate paperless case presentation, machine-generated document translation, hearing room technologies, electronic document scanning, and digital signature software. Now, you will note all of these are very, very basic. What we are talking about is much, much more advanced. However, unfortunately, when we look at India, there is still a whole lot that we don't adopt in arbitration, even in high-value arbitrations. And adopting these technologies, which, as I said, are quite basic, very honestly, in today's world, can really enhance the speed, the quality, and the whole overall experience of arbitration. Virtual hearings. We are doing, even the courts have adopted virtual hearings, even though we have moved back to physical hearings in courts. The courts are still open to lawyers representing their cases through online mode. Transcription services. Mr. Pachnanda talked about it, Mr. Mishra has talked about it, Tejas has talked about it. It just changes the way an arbitration takes place. It's just so much faster, it's so spontaneous. We've had experience where we haven't used transcription services. And very honestly, when you're crossing the witness, the counsel will put a question, the arbitrator will put the question in a way that they think the question is, and the witness will answer, and the arbitrator will put the answer in a way that they understand the answer is. So the whole purpose of the cross is honestly lost in the process, and it just takes so much more time because it's not a conversation which is happening. I ask a question, it's interpreted, it's dictated, it's written down, just goes on and on. So that's something which is like really useful, and we in the industry, we should really, as in-house counsels, should think about adopting it. E-documents. When you're having virtual hearings and if you have transcription services, if you have e-bundles of documents, it's just so much faster. There are agencies who will just quickly bring up the documents. Within seconds, they'll highlight the relevant paragraph that you're showing to the witness. It just increases the efficiency of the whole process. Artificial intelligence. Ruchi just talked about artificial intelligence and what all artificial intelligence can do. So apart from document review, e-discovery, there is predictive analysis of where your case could be. And as in-house counsels, that could be something which is a very useful tool for us. So even before we're advising our businesses as to whether we should go in for a litigation, we can use this to see how the success case is, does it make sense, what are the different strategies that we could adopt. Predictive analysis is also being used for choice of arbitrators. And very honestly, Kluwer is one of the good platforms for doing that because they have so much data on arbitrators And predictive analysis can help you with how an arbitrator would be looking at your case. And when you're nominating an arbitrator, that's something which could be helpful. So just by way of example, if you have a case which is very contract dependent and you really don't want to go into it should not go beyond the boundaries of the contract, then you want an arbitrator who goes by the contract and doesn't really try and go into equity and principles of fairness in a private contract. So you want to actually know what kind of a arbitrator is there and what is it that you're looking for. So that's something which is very helpful. Now, let's also talk about legal framework. Do we have the legal framework in India to actually help us and recognize all these practices? So largely, yes, India is poised to adopt all these technologies and to be able to do arbitration using these technologies. So if you look at New York Convention, which is basically the mother document for all international arbitration, there is nothing in the New York Convention which stops us from using any of these technologies that we've talked about, because these are all subject to parties' consent. And the main thing that the New York Convention wants is a fair hearing for the parties, and that is something which is possible. Yes, you have to take certain safeguards, you will have to look at the equal opportunity, whether the parties have enough time and the connectivity and all of that. Yes, those challenges will be there, of course. We will have outages, internet outages and all of that. But yes, it is possible. The framework is there. Arbitration and Conciliation Act also permits online hearings, etc. There is no bar there. So all of what we've talked about, it is possible. Indian Evidence Act, which is now Bharatiya Sakshya Adhiniyam, also recognizes even evidence by way of online evidence, because they say orally or digitally the evidence can be presented. So that's again something, the law is there. If you look at international IBA rules that Tejas was just talking about, they very clearly say that evidence can be given orally or by virtually. So the framework is there, it's present. We just need to use it more efficiently. Most of the international institutes have brought in protocols and guidelines on how to use technology. As an aftermath, this is one of the best things that has happened out of COVID, that we've all gone digital. We've recognized the value of technology, virtual hearings, and all the benefits that can come. It just makes life so much more efficient. Before I go on to the challenges of going technology driven, I just want to highlight some of the very major, these are just the basics as I said. But internationally, if you see, the arbitration is being taken to the next level. There are institutes, there are websites, etc., which provide arbitration services which use AI and blockchain, etc., to provide your solutions. So I was just doing some studies, and there are cases where if you have taken some online services and you're not happy with online services, it's a low value, you really don't want to go into a detailed arbitration. So these kind of websites, you can go lodge your case there, and a person who is actually a domain expert, maybe a website designer, will look at it, they will say, okay, I want to be the arbitrator. They will see the case and they will give their decision. And the website, using AI and blockchain, very honestly, I don't understand how that works, but using AI and blockchain, will give a decision in that matter. Now that's absolutely amazing. So basically, an individual could be replaced by AI. to give you arbitration decisions. Now, if you look at New York Convention, nothing bars you from having an AI as your arbitrator, rather than having people as arbitrator. Indian Arbitration Act does say that it has to be a person, so we cannot yet go for AI, thankfully, so we still have jobs. But internationally, it is possible. And there are institutes, and I read about an institute in China, where they have AI, and once the case is finished, within 5 minutes, the AI assistant provides a framework for the arbitrators. That's how quickly they will analyze the whole system, all the documents, etc., and provide a decision. So, yes, we do not, it's not, it has its shortfalls because arbitration is confidential. So the data on how the AI is, the decisions that are there, is not enough for AI to be very efficient and to be foolproof. But yes, we are moving towards that. In India, we really need to adopt technology to make arbitration more efficient, and just for in-house lawyers and even for lawyers in practice, I just think it's just something which has to be there, that we don't really have an option not to adopt it, and the sooner we do it, the better it is for us as a country. I think, and coming to the challenges, we've talked about confidentiality, we've talked about data privacy, technical glitches, etc. These are all something which can be overcome. It is not something which is not doable. And there are guidelines. There's a Seoul protocol which has been published. Even SIAC has guidelines as to what are the questions that you should look at before you decide to go purely, virtual hearings and e-bundles, and you decide to adopt all of these technologies. But honestly, these challenges, I personally feel that is something which are doable and which we should overcome. And I think Kluwer is doing a lot of good work in providing the database and using AI, etc., for transforming arbitration. So we are an oil and gas company, so oil and gas disputes in India are not that much. So we use Kluwer a lot to get international precedents. And we have used that information to help with our cases in India. And that's just amazing. As to sitting in India, you can reach out and you can actually look at information, get information, find precedents in international as well as domestic arbitrations. Thank you so much.